Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefield of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Oh my gosh, we have a lot to talk about. I feel like I say that every week because we do. So today, we are going to talk about these agreements that we make with our employees where we give them a benefit and they get to keep the benefit as long as they stay with us. It's a little handcuff, all right? And I want to talk about this and what we should be doing to minimize your liability for these types of agreements. Okay, so first of all, let's look at the big picture here. When we're talking about this type of a situation, and let me give you an example. You agree to send your employee to college. You tell them that you will reimburse them for college classes they take, as long as they stay with you. And if you reimburse them for a class and then they don't stay with you for another, I'm making this up, 12 months, then they have to pay you back for what you paid, which makes sense, right? Because what you're telling them is, if you continue working with us, then we will reimburse you. So if we reimburse you first and you leave, then that means you owe us, okay? And I get the desire to want to do that. But the California legislature last year in 2025 decided that there was a lot of abuse in this area. So they came up with a new law which created Section 16608 of the Business and Professions Code in California. And the point of it is that it is a public policy in California to allow employees flexibility to move among different jobs. The legislature really looks down on anything that will inhibit an employee's ability to move, to go to a better opportunity, etc. So it's this old concept of the golden handcuff, right? They don't like golden handcuffs. So they consider it to be an unlawful restraint on the employee's ability to move to another job if you don't have these, what we call stay or pay agreements, if you don't set them up appropriately. All right, that's the issue here that we're talking about today. And it's really something where it's kind of a handcuff in disguise, okay, hence the title of the podcast today, because you're not saying it's a handcuff, but that's essentially what we're doing, right? And of course, we're very transparent about it. We want it to be a handcuff because the point is we don't want you going anywhere. And if we're going to give you this benefit of a college education, we at least want you to stay here long enough for us to get the benefit of it. So what I want you to understand is California is now aggressively scrutinizing these stay or play agreements, all right? And you have to think of this new law as really a shift from, oh, I came up with a great idea for creative compensation, to this could be an illegal penalty. And it could end up with a bunch of penalties and a PAGA case and all kinds of things. So the reality is plaintiffs' lawyers are actually going to start searching for these repayment provisions. They've spent the last 15 years litigating PAGA, making gajillions of dollars. And now they need to find the next easy moneymaker. And this is it, all right? Because a lot of people are not changing their agreements. They heard about the law. They understand that it passed. They know it was in effect on January 1, but they haven't done a darn thing about it. So plaintiffs' lawyers are on the lookout for this. So when you get one of those letters from a plaintiff's law firm or even a request from your former employee saying, I want my personnel records and I want my payroll records, this is one of the reasons why. They're trying to figure out if there's something going on here in terms of a stay or pay agreement, in addition to everything else they might sue you for. So one of the problems that we have is to the HR universe, which includes me, we think of these agreements really as just a bonus agreement, right? Look, I'm going to give you a retention bonus. I'm going to pay you $5,000 if you'll stay till this deal closes, right? And then the deal's going to close in 5 months, and so therefore I need you to stay for 5 months. We think of that as a bonus. But if we have a clawback provision where we're saying if you leave before 5 months, we're going to come take back part of that bonus, That's where we end up with a problem under Section 16608. And the last thing you want to be is a test case under that new law. All right. We don't have any court decisions on this yet because remember, this has been a new law for only 2 months, right? So we haven't had time for anybody to file a lawsuit and get up to the appellate court for a written decision. We're a couple years away from that. So in the meantime, I don't want you to be a test case. So think about the common examples of a stay or pay agreement. Training, right? I'm going to send you to get your SHRM certification. And if you stay here for 2 years, you don't have to pay me back. But if you leave before 24 months are up, you're going to have to pay me back the $4,000 I paid for you to get your certification. Sign-on bonuses, where we say, okay, we're so happy that you want to come to work with us. If you agree to start by April 1st, I'm going to give you $10,000. But if you don't stay for a year, you're going to have to pay me back all or a part of that $10,000. Retention bonuses, which we talked about earlier, where I'm saying, okay, I want you to stay, right? I'm trying to encourage you not to take another job. So I'm going to give you a retention bonus, but you have to work here for a certain amount of time to get it. Now, remember everybody, there's 2 ways to do this. One way to do it is give it all up front and then say you're going to have to pay it back if you don't meet the service commitment, right? If you don't stay long enough. The other way to do it is to break up the payments into smaller portions and spread them out over a longer period of time so that if they leave, you're only losing a part of that, right? So, okay, you have given the 1,000 at the end of month 2 and 1,000 at the end of month 4 and another 1,000 at the end of month 6 and another 1,000 at the end of month 8. And then they leave in month 9. Okay, well, you haven't given them all of the money yet. So there's 2 different ways to do this. The law is focused on the clawback way, okay, where we're clawing back a payment that we've paid to you. If you don't ever want to get repayment, then none of these rules are going to come into play, okay? So under the new law, there are a couple things you can do as an employer to cause a problem. The first thing is you have repayment option amounts that are not tied to your actual costs. So for example, let's say that you said, I will reimburse for you to go get this college degree. And I just reimburse you per class, right? So you get a satisfactory grade in a class, then I give you the money. And I want to get that back. But I tell you, if you leave me within 24 months, you've got to pay me 3 times what I paid in your tuition. That's not going to work, okay? Can't do that. Now, of course, these stay or pay agreements are not always about things that you are paying out as a cost, right? Most of the time, they're about bonuses. So if you have a repayment that is triggered, even if the employee resigns for good reason, let's say they resign because they have a medical issue or they're pregnant or they have to take care of their mother in Toledo. Well, that's a good reason. If you still say, well, you resigned, you're going to have to pay me back, that's a problem. Or a repayment provision that functions like a penalty, right? So basically says, you're going to have to pay me a little more, or you're going to also lose this other benefit. Besides having to pay me back, I'm also not going to give you a good reference, okay? Sounds more like a penalty and not a cost recovery. That's going to be a problem. And then anything where you're really trying to deter what the legislature calls lawful job mobility, right? Where you're trying to deter them from moving on to another opportunity. When you do any of these things I've just listed, you have a flat repayment amount that is not tied to your actual costs. Your repayment is triggered even if the employee resigns for good reason. You have repayment provisions that look an awful lot like a penalty and not like cost recovery. Or you just generally have an agreement saying, we don't want you to ever leave us, although you're still going to be an at-will employee, right? That's going to be a problem, all of those things. And the legal risk is several-fold. Okay, so if you do any of these things, you have a lot of potential risk. First of all, it could be considered an unlawful restraint on trade under the Business and Professions Code. And there's all sorts of penalties and damages that people can seek for that. It's like a non-compete or a non-solicitation, which are definitely disfavored in California. You may have wage deduction violations because if you're trying to claw back the money and you're taking money out of their paycheck, you're going to have a paycheck that's incorrect. So you're going to have wage deduction problems. You're going to have penalty exposure because what if you withheld money from them while they were working there or after they left, and then they go get a 203 claim, which is Labor Code Section 203. Remember, waiting time penalties. They say you should have paid me my final wages. You didn't do it in a timely manner, so you owe me 30 days at my daily rate. You've got PAGA, all right? PAGA, Private Attorney General's Act. This is how all those plaintiffs' lawyers made all that money since 2005. That is going to be another way that you could be on the hook for liability. And then there's class action potential if you do this on a broad basis. So you have substantial legal risk if you do this. Now, how can you avoid the risk? Well, there are 5 questions I want you to ask yourself when you're looking at these agreements. Okay, first of all, is the repayment proportional to the actual cost? So let's say I'm going to give you a $5,000 bonus and I say you have to stay for 12 months. If you leave at month 6, I shouldn't be requesting more than $2,500 because you've worked half of the year. Therefore, in essence, you have worked off half of that bonus, okay? So if I'm telling you I want the whole $5,000, that's not going to fly. So you want to ask yourself, first of all, when you write these agreements, is the repayment proportional to the actual cost? Second of all, does the repayment obligation decrease over time? Which of course it should, right? As time goes on, you're going to owe less and less. Is it tied only to a voluntary departure and one that doesn't have a good reason? For example, my mother's sick or I'm sick or my husband got transferred to Toledo, whatever, all right? If you have it tied to a termination, you can't terminate the employee and then say, by the way, you owe me that bonus that I paid you. Not going to work. All right. Now, the only exception to that would be if you terminated them for what we call good cause, which is not just a reason, remember. Good cause is something like they stole from you, they assaulted somebody, they lied about something really important, that kind of thing. Ask yourself, does this seem more like a penalty or is it just me trying to recoup my costs? Right? So am I punishing? Oh, you're going to have to pay me back part of that bonus and I'm not going to give you a good reference and I'm going to make sure that you get assigned the new office in the basement with no windows. Okay. And then this one is touchy-feely, you guys, but I swear to you, everything you do, you should have this lens on it. Would it survive a plaintiff's closing argument? In other words, are you going to be able to convince a jury that there is a reason why you have done this and you have been reasonable? Okay. You have not tried to impose a financial handcuff on somebody. You are looking at how you are rewarding good employees. You want to retain good employees. You do that through culture and you do that through opportunity. You do not do that through a stay or pay with a clawback. All right. That is just the wrong road to go down. And one of the things I want you to think about is if you read your agreement and it feels punitive to you and you're sort of thinking, gosh, that's kind of tough, then don't do it because that's exactly the lens that a court or a plaintiff's lawyer is going to have. They're going to look at it and they're going to say, wait a minute, you're trying to restrain them from going to a different job. You're trying to limit their opportunities out there in the universe. That's what's going on, right? That's what's happening. Okay, so I want you to remember when we talk about these issues, it's not that you can't do it. It's not that you can't have a retention bonus where you have a repayment clause. It's not that you can't have a hiring bonus with a repayment clause. It's not that you can't have tuition reimbursement with repayment. You just have to write it correctly. Okay, that's the thing I want you to remember. And again, if it feels like you're punishing, then you're going down the wrong road. All right, everybody, thank you so much for your time today. I love these podcasts with you. I meet people out there every day who tell me, it's crazy. Jen, I love your podcast. I love hearing you guys talk. I love it when Joe's on. Like, It's so awesome. I love connecting with all of you this way. So as always, if you have ideas, suggestions, complaints, feedback, I'm all ears. I always want to know. Please tell me. Don't forget, by the way, Employer's Lawyer is up and running. And of course, we here at Shaw Law Group are always here to help you if there's anything you need. Thank you so much for your time today, guys. Go out and do something nice for someone, and I'll see you soon. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.